rise. The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. Good morning. We are here today on Arizona Court of Appeals Division 1, number 1 CACV140511, AEA Federal Credit Union versus TNK Enterprises Auto Sales and Leasing, LLP. Counsel, as you know, both sides are allowed 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal, but you're in charge of keeping track of your own time if you do that. The clock on the podium reflects the total amount of time you have remaining, including what you may have decided to reserve. We record these proceedings so when you approach the podium, and for Mr. Kelly, each time you approach the podium, if you would do us a favor, please, of reciting your name and the name of your client for the recording. We'd appreciate that. We have read the briefs and we reviewed the record, and we've also discussed the case in our conference this morning. So with that, you may proceed.
Thank you. Thank you. Jason Kelly for Appellant TNK Enterprises Auto Sales and Leasing, LLP. I want to start by pointing out that there seems to be some confusion, at least from the side of the appellant. No one's complaining about the loan documents or the form of the documents or who was sued or that there was an invalid judgment against Ken Stevenson or Maria Stevenson. That's all great. What we're talking about is who owned the cars. The evidence in the record, the scant evidence that we have in the record, indicates that the partnership, TNK Enterprises, owned the cars that were taken. They were taken, again, and this is important, they were taken by a sheriff who showed up with his badge and his firearm and took it. When the sheriff shows up, due process is implicated. That's the Walker case. Everyone agrees Ken and Maria got some money, but the partnership never received the money, and the partnership owned the assets. You know, the statutes I submit are fairly clear. ARS 29-1011 says that a partnership is an entity distinct from its partners. ARS 29-1041 says that a partner is not a co-owner of partnership property and has no interest in the property. And ARS 29-1014A says property is partnership of the property if acquired in the name of the partnership. Now again, the evidence we submitted shows that the partnership owned the cars that were taken.
And the partnership you're talking about is a partnership of the two Stevensons?
Correct.
And that existed back in 09 and 2010 and so on?
The partnership was created in 2002.
Yeah.
May
I go ahead?
Yeah.
The LLLP was created more like 2014.
13 or 14, I believe.
Okay, but I think I've understood. Correct me if I'm wrong. That you're treating that as though they're one and the same, just over time.
And it's just, and I think there's a statute that controls that as well, Your Honor.
I'm sorry.
29-1101 indicates that it's just a conversion of form.
Okay, so I wanted to make sure. Okay, and part of your big point here is that T&K as the partnership was not named or sued, and if not named, then I suppose your point would be that they weren't served either.
Correct, Your Honor.
Well, normally, don't you serve a partnership by serving one of the partners?
You have to serve the partnership, though. If Jason Kelly's in, for the sake of argument, Kelly and Garcia partnership, and Jason Kelly gets served, that doesn't mean Kelly and Garcia is served.
Depends on what the summons says?
I think it depends on what the summons says.
Maybe the complaint.
Well, both. The complaint doesn't indicate that the partnership was ever to be named or put in as a defendant. The summons, there is a summons from February of 10, filed February 26th of 10, says that Ken Stevenson, owner, was served. He's not an owner. The statute I read to the court indicates that partners are not owners for purposes of partnership law.
So the two partners, the two general partners had notice of the lawsuit, but your point is that the partnership, the general partnership, was not served. It wasn't named as a general partnership, and it wasn't served.
Correct.
What authority is there for the proposition, though, that a party, a non-party, can use Rule 60C to come in after the fact and undo an interlocutory order issued in a lawsuit?
That's two valid questions, and I'll try to answer each one. First of all, there's some.
I thought you were going to object it was compound.
It's compound, and they're both
I'm trying to
the
figure out what the two
defenses.
questions were.
I'm not sure it is.
They're both the defenses raised.
Okay.
And they're the only, I would submit, valid defenses raised, and so I'd like to address those. First of all, there was a question as to whether there should have been a motion for intervener. I submit that I agree that didn't occur. I submit that the trial court allowed the intervention to occur by hearing the merits of the motion, overruling the objection. So, you know, although there was not a pleading entitled, please allow me to intervene to file a motion to set aside, I agree that it didn't occur. In substance and in reality, that occurred when the judge heard the motion on the merits.
Isn't on the intervention issue, isn't undue delay a factor in whether a court would allow intervention?
Yes, if it weren't a Rule 60C4 question.
Well, but if your argument presumes that we can get by the intervention because the court necessarily granted the motion to intervene, the court found undue delay, so...
The court found undue delay in bringing the Rule 60C4 motion. The case, Master Financial, I believe it is, there's a few cases we cited, says that even in the case of unreasonable delay, Rule 60C4 motions must be entertained because they go to subject matter jurisdiction, personal jurisdiction, and due process. The cases I cited, I believe it was the International Glass case, favorably cited cases that brought Rule 60C4 motions 22 and 30 years later. There's no time limit on due process, according to the case law. So,
well, due process.
But you're talking about the right to intervene, and if the court is saying you're untimely, isn't that sort of an implicit, if I didn't rule on the basis of Rule 60, I'm going to say that this is an untimely intervention?
I believe the court's ruling, and I believe it's on page 23 or 24 of the transcript, was this was an untimely Rule 60C motion. I don't think the court ruled on whether the intervention was timely. But for the sake of argument, I would submit if we're bringing a Rule 60C4 question, whether an order is void, whether an order is constitutional, whether an order was entered with a lack of jurisdiction, the intervention can't be untimely because the intervention is just related to the underlying substance of the issue raised. Well,
but the partners, the general partnership, certainly had notice of the seizure and could have raised the due process argument that the LLP made 4 years later. Could have raised that when the sheriff showed up on the lot.
Well, that's an interesting question, and and I put it in the docketing statement. There is a related appeal, and I incorporated by reference in the trial court the facts from that other case. The partners had 100% of their assets and income frozen and seized in January of 2010. No paycheck, no assets, couldn't move. We're trying to undo that now. But yeah, they had notice of this. They also had, on an ex parte basis, everything taken from them. So sure, they had notice. Sure, they could have hired a lawyer. You know, you come to me, a client comes to me, I said, okay, where do you work? Well, I can't work anymore. Do you have any assets? Well, I don't have any assets anymore. I can't defend a case on a contingency basis. So yeah, they had notice. They also had no money.
But isn't that a separate lawsuit? That seems different than coming in and trying to set aside an interlocutory order in this case.
Is that a different lawsuit? No. Because the two entities were sued separately, but it's all based on the same activity from the credit union. And, you know, we've cited that in these pleadings. I also cited in the other case. The Mr. Bill Little, who's now in federal prison, was upside down on his lending ratios, and we've got the email in the record. He conspired to take over these companies precisely because they were profitable. What he did was freeze everyone's money, took everyone's without notice. So you've got a guy, 70-something years old, who's now had his life savings wiped out and his only income wiped out.
You're talking about Mr. Stevenson.
Yes, Your Honor. As to the interlocutory nature, 2 points. I looked up 12-20 ARS 12-2101 last night. I couldn't find a right to appeal the grant of a replevin order. I found under 12-2101A5C, you can appeal the dissolution or refusal to dissolve a garnishment or an attachment. I'm not sure if this is a garnishment or attachment, but even if it is, you're only entitled to appeal the dissolution of it or the refusal to dissolve it. So it's a non-appealable order that I submit merged into the final judgment. ARS 12-1301 at SEC handles replevins. Starting at 12- let me get the number right. 1307, they start talking about what happens with the replevied goods, whether there's a deficiency, whether there's a surplus, whether the defendant wins, whether there's a return of assets, make a bond claim. So 12-1307 through, I believe, 12-1314 merges the replevin into the judgment. So we weren't, you know, there was no right of appeal of the original replevin. We have a final judgment, merges all the prior interlocutory orders. So I think you can appeal that. I mean, you can appeal any other interlocutory order that you don't have a right of appeal on. This is just one of them.
And I think this is the second part of the allegedly compound question earlier. What authority is there for the proposition that Rule 60C to undo a judgment may be used to vacate an interlocutory order that has been subsumed within the judgment? Because you're really not asking to undo the whole judgment.
I'm not asking for anything on behalf of Ken Stevenson or Maria Stevenson, the only parties against whom the judgments were entered. We're asking to undo the order, the replevin order, because as we pointed out, and you know, the person who owned the cars wasn't sued, the person who owned the cars wasn't served. There's no evidence in the record that AEA had a security interest on any of the cars. And there's no evidence in the, well, the only evidence in the record is that this non-party from whom the cars were taken was the owner. So you can't, you know, you can't sue party A and say I want the cars from party B on a replevin.
You're saying it merged with the final judgment, and that makes it appealable, but you don't take issue with the final judgment.
No final judgment was entered against T&K, the partnership, because T&K, the partnership, was never named. I'm not sure what I'm supposed to do at that point. I mean, I'm sort of in a bind there. I got to get this to appeal because, you know, the trial judge, I submit, committed an error. And I'm being, you know, we were allowed to intervene.
I guess I'm not completely tracking why there's not just an independent lawsuit if your client's a completely innocent party that had no notice of anything that was happening. Isn't there a separate remedy other than trying to come in and challenge the final order in this case, or the interlocutory order?
Yes. I don't think it's exclusive remedy, though. When I sue for conversion, I want to come back and argue this order got set aside because it was unconstitutionally entered as a violation of due process. Can I argue that without this ruling? I mean, I suppose. But the point is, and Your Honor's discussing practicalities, and trust me, we've been over the practicalities numerous times. The fact of the matter is, though, for this court, I submit that if the order's void, the order's void. I think the the panel asked all the questions of the points I was going to cover, so unless there's any further, I'll sit down now.
Any further? Thank you.
Good morning. May it please the court, I'm John Garcia representing the Appali AEA Federal Credit Union. What the appellant is asking the court to do is actually something very dangerous that, argued at the trial level, is really no different argued at this appellate level. He's asking the court to permit a non-party who did not exist at the time of the suit, who did not exist at the time of the trial, and who did not exist at the time that final judgment was entered in this case, to upset the finality of the court's judgment. A final judgment, mind you, that was never appealed, and that is actually not even appealed here. And so, if you take a look, step back to one of the main points of contention that Mr. Kelly raised in his argument this morning, it all centers around this partnership, the Triple LP, I'll call it for short, being aggrieved because it supposedly had some type of an interest in the collateral that was replevied through the 2 provisional remedies orders that were issued by the trial court. Well, if that indeed had been the case, that this is Ken and Maria Stevenson's partnership, and that Ken and Maria's partnership was not served, it was not made a party, it had the collateral. Even though all those facts defy the loan documents, they defy the UCC1 filings, all of the security instruments. Even if we were to accept that argument at face value, it's not as if the trial court did not consider that issue. In fact, if you look at the trial court's transcript, which is a part of this record, from May 19, 2014, the court at page 24 of the transcript, starting at line 17, specifically found that the Stevensons, whether they were principals of T&K, whether it was a sole proprietorship or a partnership, would now be stopped from having the orders set aside at this stage of the proceeding on the basis that, well, we contended all along that it was a sole proprietorship. We argued it was a sole proprietorship. We signed the documents, it was a sole proprietorship. But now we're saying it's a partnership months after the judgment was entered. The court then said the motion to set aside the orders is denied. And that was the end of it. And, you know, speaking of practicalities, what was the practical effect of what happened to this collateral when the 2 prejudgment interim provisional remedies orders of replevin were entered? The practical reality is that if another party indeed was the owner of that collateral that was seized and was not a party to that suit, because I can guarantee you that if you look at the record, the loan docs match who was sued. The loan docs and the parties to the suit, they match throughout to the bitter end of that lawsuit.
Thing about a partnership.
Well, there's references into the fact that the 2 operated as a partnership, but in effect, both were general partners anyway. And so, you know, when we take a suit based upon breach of contract and replevin, all of that coming out of the loan documents, and you look at who were the parties to those loans, it was mainly Ken Stevenson, a sole proprietorship doing business as T&K Enterprises. Maria Stevenson appears on some of the loan documents, but in effect, that's who the parties were that were the borrowers. Those were the parties representing to AEA Federal Credit Union that their inventory sitting on their lot belonged to them.
What if it didn't?
Well, and if it didn't, and all of that collateral was seized, then this partnership that didn't even exist in the form that we see as the appellant would have had to go back in time, be formed, file a lawsuit against AEA, a separate independent lawsuit, which it could have sought to consolidate with the main suit, the suit that we're dealing with. I would have filed probably a separate lawsuit. I would have filed for a temporary restraining order to show cause, get a hearing on that order to show cause to make the TRO permanent, at least for the pendency of the case until trial on the merits. And then after I get that order well, probably with notice to the extent I could, but I could obtain it ex parte, and then from there set the thing for a hearing, consolidate it with the other action, and put a stop to everything. And it could have happened that way. But, with as old as this case is.
Let's say they just weren't aware of it. It's Smith Corp that owns the cars. Could they come in after the fact, file a separate lawsuit, and say there was some sort of fraud on the court?
Of course.
You took our cars.
Your Honor, it's an issue of damages at that point. This is, when damages are an adequate remedy at law, there's no reason to say, well, we're going to undo these replevin orders and give you your inventory back, because it is a claim that damages can easily be calculated. You've got inventory, you've got value, you've got interest value you can assign to that, potentially lost profits. You've got damages. And so that other entity, if it owns something, and in fact, from what I understand, the LLP has filed a separate action that's pending currently in the Maricopa County Superior Court system, which, obviously is not in front of this court, but they've already filed something else. So it's not as if this, and I would imagine, I'm not involved in that case, but as old as this case is and as old as the seizure was, there's potentially all kinds of statute of limitations issues and other issues that they'll have to confront in the context of that litigation, which have nothing to do with this collateral attack from an entity that was formed well after the fact, that was designed, was calculated to resurrect defenses that were not raised in this proceeding. Mr. Stevenson was represented. Who is the principal? He was the operator. He did everything. He was T&K. Mr. Stevenson was represented by counsel in the early parts of this case at the trial level. There were problems with his counsel, resulting in his counsel's withdrawal, but Mr. Stevenson did not abandon the case until the trial on the merits. Mr. Stevenson actually participated pro per at just about every hearing that we had. In fact, when I filed a motion for summary judgment, he came out of the woodwork and filed an affidavit, which I felt was completely deficient, and the court should have summarily entered judgment in my favor. The court bent over backwards to give him every benefit of the doubt and the time to make his case, including setting the trial date way out, giving him adequate time to come and prepare and be present. Mr. Stevenson did not show up. Maria Stevenson did not show up. And in fact, even though Maria Stevenson should have had her rights foreclosed at the trial court was even so cautious as to say, well, a long time ago you filed a motion for default judgment against her because she never appeared. And so even though you had a trial, even though you proved your entire case on the merits with testimony and everything else that a bench trial would have, I'm going to require you to have an evidentiary hearing on top of the trial. And so we retried the case again, and the result wasn't any different.
What's the response to Mr. Kelly's contention that the reason that Rule 60C allows a motion for relief from an interlocutory order in this case is that the interlocutory order itself wasn't appealable? It's merged in the judgment, and therefore we need to construe Rule 60 to allow an attack on an order short of a judgment.
I think if we take the briefs as they have been crafted and pled, it is clear, and even at the trial level with the motion to set aside, it was clear that Mr. Kelly's client, as the appellant, is not attacking the final judgments entered in this matter. the issue of merger has not really come up, other than for me to say that, you know, the case merged into the final judgments, which were not appealed. They were never timely appealed. And so if you look at Rule 60C, number one, you have to be a party, or you have to be a party's representative. The rule is clear. If the court allows a non-party that on the facts of this case came out of the woodwork after the trial, after the judgments, after everything was said and done, newly formed and saying, we're the same entity. Well, the record shows that they're not the same entity. In fact, there's a general partner that's some type of an entity. It may be Arizona or Texas or Nevada or something of that nature. The disclosed partners are not the same partners that are shown in the Secretary of State's website. This is not the same entity. And in fact, if any of those transfers would have really occurred and there was some type of value there, Mr. Stevenson is so far upside down in his obligations that surely any transfer to outside entities would constitute actionable fraud on the basis of the conveyance under Arizona's version of the Fraudulent Transfers Act. So there's all kinds of problems with him even claiming that you know, he has the ability to have an asset and transfer an asset. There's nothing there to transfer. There is no partnership. This is all a ruse to try to resurrect offenses that weren't raised. And under Rule 60, you've got to have a party's legal representative raising the motion. We don't have that here. We don't have anything that suggests that somebody that was never joined as a party under Rule 19, Rule 20, never intervened under Rule 24, they just waltzed right in and filed a post-judgment motion to set aside. They have no ability to do that. You know, some random, you know, unrelated party can't just go file something in a court and expect that it to be entertained. They actually have to be joined in a way that the rules recognize. And the rules are not, you know, obviously there's the argument of substance over form, but this is not just a question of form. This is a question of substance. And even though the rules are intended to do justice, and amendments are supposed to be liberally granted and so on and so forth, that's to a party. That's to somebody that's engaged and involved in the process. Mr. Kelly's clients is not. The real issue here is not due process, and it's never been due process, because process was done in this case. Process was done after the preparing of the complaint, the filing, the service of the complaint, the opportunity to be heard over a period of years in this case.
I heard you say earlier, and I hope I was following correctly, that the financing documents pretty much all refer to Mr. Stevenson, DBA, T&K, and then sometimes Maria is included, I guess, and sometimes not. But I'm not sure I heard you say what the titles to the vehicles say.
Well, the titles to the vehicle, these are as inventory. Inventory, you know, it depends on how, you know, the way to, you're not going to find AEA, for instance, as the owner of the vehicles, even though it lended the money. Because it lended the money, but the debtor has to have rights in the collateral. And so how do you, you know, perfect a security interest under Arizona law in inventory? You file a UCC1 financing statement. That's the way you do it. Now, do certain lenders, as a matter of course, require lien notation for scores of inventory, a car lot that may have hundreds of cars, maybe less, maybe more? Sure, some of them do that as an extra precaution. In fact, some of the lenders hold the original titles and won't release them, whether or not they've noted their liens on the title or not. But do they need to do that? No. The perfection of a security interest in inventory is accomplished by the single act of filing a UCC1 financing statement. And so after that, if someone comes in and says, no, that's my collateral, I own it. Well, they've already been charged of record if they were to go look at the filings in the UCC filings with Secretary of State. Someone claims an ownership interest in those vehicles. Not just Ken and Maria Stevenson, but operating under that trade name of T&K. So the world has notice.
Does
that
the record, though, contain evidence of who did hold the titles, or more specifically, what person or entity the titles said owned the vehicles?
I'm not aware of that right off without examining the record and seeing. I'm not really sure if it ever really came out, and I'd be guessing who physically held the titles.
Or what the titles said?
Or what the titles said. But, you know, from the standpoint of, could Mr. Stevenson have taken the title and done something with it to transfer, defrauding the creditor, AEA, by not telling them that I took a piece of your collateral and I transferred it to another entity, didn't pay you for the collateral like I'm supposed to? He could have done that. Does that mean that AEA didn't have a prior perfected first priority position secured interest in the inventory? No. It just means that that creditor has suffered a breach of contract of which it is unaware and been defrauded. Mr. Stevenson has a criminal record which is noted in the record for doing very funny things with the titles of vehicles and in the car business generally.
What if the used car lot owner says to an AEA, I and my sole proprietorship own these vehicles. This is my inventory, but the fact is that they're not owned by him. They're owned by the ABC Corporation, and the lender AEA still, you know, it does its thing. It lends money. It files a UCC1, but no one is paying too much attention to the fact that the automobiles are actually owned by somebody else.
Well,
doesn't that somebody else have a right?
You know, if another party has a right that claims an interest in it, they've got an independent action, whether it has merit or not, and whether it will result in damages is a question for the court after the issues have all been litigated. But as far as AEA is concerned, as between them and the borrower in this case, which were the only defendants in this action, the ones that signed the loan documents, the ones that affirmatively represented in those loan documents that this is their collateral and they're going to continue to buy collateral with the loan advances, and they understand that AEA and they covenant, they represent and warrant that AEA will have the first priority security interest in the inventory. And so regardless of what happens after that, if AEA comes in and takes all the vehicles but they're owned by somebody else, those people that took title to it after the fact take it subject to the lender. It's no different than a first and a second mortgage on a house.
But how about those who had title, the ABC Corporation in my hypothetical, had title before that?
If they had title before the inventory became collateral of AEA, then again, they have an independent action. They were not the subject of the suit. The subject of the suit was a suit on the loan docs. That's what was carried to finality at the bench trial and on the judgment.
Okay, I follow you, I think, but the vehicles were seized and sold.
Sure.
What if they didn't belong to Mr. Stevenson personally, but to his partnership?
Well, it's one and the same. You know, Arizona, you know, if you don't have another entity, the partnership is two people. It is really, you don't even have to file a partnership for it to be a partnership, a general partnership. General partnerships can exist all over the state without anybody really knowing that it's a general partnership. Any two people carrying on an enterprise for profit have formed a partnership, whether they know it or not. Whether they know it or not. A lot of people don't realize that. And you know, what was Stevenson's intent? Doing anything and everything that he could to make money at the expense of others. And did he cause huge losses to AEA Federal Credit Union? Sure. Were there other issues involved internally with the loan officers and stuff like that? Yes. But that was not the institution. That was crooked people who did bad things that hurt a lot of people. The wake of this case was huge because there are people with title issues. There are people with claims potentially against AEA, potentially against Mr. Stevenson, potentially against Yuma Funding. It was a very messy situation, admittedly, but none of that changes the fact that there is no claim here from the LLP to be involved in this case. Thank you very much, Your Honors.
Thank you, Mr. Garcia. Mr. Kelly.
Thank you. I think, Your Honor, Judge Gemmell and Judge Johnson, you both asked some pointed questions, and I want to highlight some of those, but I want to jump back to this Rule 60C for a second. None of the rules of the civil procedure were designed to precisely handle what happened at the trial court in these two companion cases. Okay, there was a mention that the actions of AEA's staff caused a lot of damages to people. The people included were Ken Stevenson, his partners, the people who invested in his companies. Okay, and the trial court allowed AEA to take and seize his 100% of his income stream, 100% of his assets. He had an attorney for a while defending his own personal assets. You've only got so much left when someone takes away your job and your life savings. He defended his personal assets first. When the money ran out, his attorney withdrew, and he was forced to represent himself in these two cases.
But you're not suggesting Mr. Stevenson had a right to come in through Rule 60 and reopen the case?
They have him dead to rights on that contract. Ken Stevenson and Maria Stevenson, yeah. You heard, I don't know how many minutes worth of, here's what the loan documents say, we agree. Absent in those loan documents, as Judge Gemmell pointed out, was anything about the partnership. They're not one and the same. This is Title 29 establishes that they're not one and the same. They're different entities. There's a partnership agreement. It's another entity with different people involved in it. There's this question about there's nothing in the record except what we submitted as to the true owners of those automobiles. We dug up what we could. Why couldn't we dig up more? Because there was a second replevin order and I didn't mention this in my opening remarks, but there's a second one in January, I believe 22nd of 2010, that says you can have all of TNK's business records, all of their title documents, all of their accounting records. The judge allowed the sheriff to go in and take all of my client's internal documents. What we've been able to piece, the question as to who bought and owned those cars is in AEA's hands. The records we can find and the records we submitted indicate it was purchased in the partnership's name, with the partnership assets, and sold from the partnership to private individuals. Under Title 29, that makes at least that car
why don't you have
property.
A separate action with a remedy for monetary damages if there was some sort of fraud or improper conduct?
We do. But I submit again, that's not the question. The Maricopa County Court said because of AEA's actions, there was tolling on all the statute of limitations. But in any event, that's not what's before the court. The question is whether this order allowing the repossession of those vehicles and the use of the armed deputy was constitutional. Did it violate due process? Was there subject matter jurisdiction? Was there jurisdiction over the enter ordered? I think the panel's questions, highlight their concern about that. And I'm not going to beat that one to death.
Why is the due process not satisfied if the partners are served?
Because the entity is not the partners. That's 29 dash.
But why isn't the partnership on notice if it's the partnership's cars that are being taken and the partners know about it? Why is that a due process issue?
This is what happened in the Walker case. The title owner, I believe it was a car, went in to exercise his self-help right of repossession. You don't need a court if you have the self-help right. But he called the sheriff down to help him. And the Walker case said, as soon as you do that, as soon as you involve law enforcement, you're implicating due process. And the court said, once you went to exercise your self-help rights with that deputy, you have to give due process. Due process means notice to the partnership, means hearing for the partnership. That the partnership never got any of that process. And once the courts and the sheriff got involved, they were entitled to due process protections. Unless the court has any other questions.
Nope. Thank you.
Thank you.
Thanks to both sets of lawyers. We'll take the matter under advisement and issue a decision in due course, and we will stand in recess for a few minutes before the next argument begins. Thank you.